Thank you, Mr. Chairman, and thank you, Senator Franken, and thank you, Judge.
I say right.
I'll submit for the record, as many of my colleagues have, two more documents, an editorial from the Washington Post from Matt Witt, who experienced the hardship of depriving individuals of the ability to make their own end-of-life choices when his mother endured a painful death by refusing nutrition, and a letter from 21 national LGBT groups expressing concerns about Judge Gorsuch's opinions and whether they do indeed respect fundamental rights that would enable them to be protected from discrimination.
Without objection, those are entered.
Thank you, Mr. Chairman. Judge, I enjoyed our conversation yesterday about Hobby Lobby and your writings on assisted suicide. Now I want to return to our discussion of privacy and the autonomy of adults to make their own decisions, even when it might conflict with settled law or with the majority's view of morality. And yesterday, when I asked you whether the Constitution contains a right to privacy, you agreed that it does. And I was glad to hear that, but you went on to describe this right and its origins. And you cited, I think, the Third and Fourth Amendments and two cases from the 1920s that have to do with parenting, I think Pierce and Meyer. But you didn't mention more recent cases where the right to privacy has been central. Griswold, protecting access to contraception, Roe and Casey, protecting a right to choose an abortion, Lawrence and Obergefell, protecting a same-sex couple's right to intimacy or to marry. And I think it's important to establish that when you agreed there is a right to privacy in our Constitution, that we were talking about the same thing. In general, this area of substantive due process and right to privacy is one about which there's been vigorous debate. So I thought it was constructive for us to have a broader conversation about it. First, do you agree those cases that I just cited all relied on the right to privacy as an essential part of their holding?
Senator, you and I were discussing, I believe, some of those more recent cases in the line of 14th Amendment substantive due process case law. And all I was pointing out, or trying to at any rate, was that they have a provenance that goes back quite a ways.
That's right. So would you agree that these are cases, the ones I just referenced, where the right to privacy really is an essential part of their holdings?
I agree they all grow out of the 14th Amendment due process liberty component, which has been interpreted by the Supreme Court to include privacy in a lot of different areas.
So would you agree, just to make sure I've understood you right, that the right to privacy today extends to protecting women's right to have autonomy over their reproductive choices and protecting the privacy of intimate relationships between consenting adults, whether same-sex or opposite-sex?
You have Casey, you have Lawrence, you have Obergefell. All of those are, I think, in the line of cases you're talking about, Senator. Yes.
And so let's take a minute and look at Casey and how it explores and identifies this right to privacy. It's now, I think, 25 years old. It's a 92 case. It reaffirmed the constitutional right to choose an abortion. And the opinion of the court notes, and I'm going to quote here at some length, that these protections extend to matters involving, quote, the most intimate and personal choices someone may make in a lifetime, choices central to dignity and autonomy, central to the liberty protected by the 14th Amendment. And at the heart of liberty is the right to define one's own concept of existence, of meaning, of the universe, of the mystery of human life. Beliefs about these matters could not define the attributes of personhood were they formed under compulsion of the state. I think that's a well-known, quote, piece of the Casey opinion. Is that familiar to you?
Generally, yes.
And in your book on assisted suicide, you say, and I quote, that it remains unclear whether Casey's mystery of life passage is properly understood as a persuasive but non-binding dictum. By calling this central section of the Casey opinion dicta, are you saying that future courts don't need to pay attention to it?
No, Senator, and I wasn't even, I don't recall being that emphatic about it.
Okay.
What I said was that obviously Casey reaffirmed the right to abortion, generally, in Roe. And then the question is, what additional work does that language do?
Right.
And that remains an open question in a lot of ways, what additional work that language does.
Well, then let's explore that if we could. Should this Casey language be relied upon in other cases?
I think that is going to be an argument that counsel will make to a court, and a court will have to consider through the proper judicial process: briefing, argument, decision.
Well, let me just argue that it has been relied upon, that it was essential to the holdings in Lawrence and Obergefell. If that's correct, and it's been relied upon in subsequent key Supreme Court cases, is Casey and this particular piece of the Casey holding indisputably settled law?
Well, Senator, Casey is settled law in the sense that it's a decision of the United States Supreme Court, right? And you also have Obergefell and Lawrence. Those are all precedents of the United States Supreme Court entitled to the weight precedent, which is quite considerable, as we've discussed.
Well, and we've talked about precedent. You've talked at some length about what are the tests of precedent. And one of my concerns here is that the language in your book, I would argue, lays out a roadmap for ignoring this section of this holding or minimizing or marginalizing it. Do I misread your writings here?
I don't know what you're referring to exactly, Senator. I'm sorry.
The section in your book on assisted suicide where you say Casey's mystery of life passage is persuasive but non-binding.
Again, Senator, I'm not sure that's an accurate portrayal of the book in the first instance. I think I said that an argument could be made to that effect, at most, because you had two holdings in Casey, right? You had one, a stare decisis or precedent-based holding.
Right.
Rose upheld because it's precedent.
Right.
God bless you. And second, there was a second argument for upholding Roe, and this is part of it, this language. And so both are sufficient to the day, right? And sometimes, as a court, you ask which is the binding holding. Sometimes there's a whole law of, actually, not just the law of judicial precedent,
Right.
but a law of interpreting when we have multiple holdings.
That's right.
Right, Mark's opinion, for example, okay, which talks about how you pick which holding is binding in the future. So, Senator, we have a whole law that applies here.
I understand that.
And a whole body of case law.
And it's exactly because of that and what I think are concerns that you raise about whether this is precedent that should be relied on or a section of the Casey opinion that should be relied on, that I just wanted to emphasize, I view it as an important foundation, this mystery of life passage and the substantive due process of views that it expresses, really central to Lawrence and Obergefell. They are rooted in Casey's interpretation of liberty under the 14th Amendment. So would you disagree with me that Lawrence and Obergefell squarely rely upon Casey's view of liberty under the 14th Amendment?
Senator, I think it would be an injustice to Lawrence or Obergefell for me to sit here and try and characterize them in miniature. They are thoughtful, lengthy opinions that have a considerable amount of analysis unto themselves. And I would just say they are what they are, and they're precedents of the United States Supreme Court. And
So they are precedents, and you would view them as binding and as settled law?
Senator, they are precedents of the United States Supreme Court, do all the weight of precedent of the United States Supreme Court. And I've written a book about how much weight that is, with 12 judges from around the country, appointed by presidents of both parties. And Justice Breyer was kind enough to write a foreword. And it presents the mainstream view, the consensus view. Think about that, 12 circuit judges agreeing on 800 pages.
If you could get 50 senators to agree on something, you'd truly be worthy of
I'd be happy if I could get 20 of you to agree.
That's correct. So let me continue with that exploration if I could. So if these cases, Lawrence and Obergefell, are settled law and they are relying critically on this understanding of substantive due process that is rooted in Casey and its analysis, under what basis or circumstances would they be subject to reconsideration? When might they be open to being reexamined if they're currently indisputably settled law?
Senator, every precedent is subject to a presumption that it stays, right? Francis Bacon called precedent the anchor of the law. Alexander Hamilton said that judges, because we're life tenured,
Right.
need to be bound down by strict rules and precedents.
Right. And I think in your opening exchange with Senator Grassley, you identified just a few factors. A reliance interest,
Yes.
whether it's been reaffirmed repeatedly, whether the legal construct it was on has been upheld, or whether it's an island unto itself. Is that, am I roughly remembering your?
There are a number of factors,
Okay.
and you've named a few of them, and they're all outlined in the book, among other places, and the Supreme Court precedents.
Well, let's move to a key moment in this line of cases where settled precedent was overturned. You testified yesterday that Justice White was your judicial hero, a justice for whom you clerked. And with all due respect, I think Justice White, who was an exceptional football player and jurist and Coloradoan, But in this particular line of cases, I think he was on the wrong side in Casey and in Bowers. So let's discuss Bowers v. Hardwick, which was a case that upheld a Texas statute criminalizing sexual intimacy between same-sex couples. In his 1986 decision in Bowers, Justice White declined to extend due process protections and recognize any fundamental right of intimacy. And in 2003, the Supreme Court directly overturned Bowers and Lawrence. Justice Kennedy wrote the Lawrence decision in reliance upon this Casey language, and he didn't mince words. Justice Kennedy said, and I quote, "Bowers was not correct when it was decided, as it is not correct today. It ought not remain binding precedent. Bowers should be and now is overruled." You clerked for both justices, White and Kennedy. Was Justice Kennedy correct in stating that Bowers was wrong when it was decided?
Senator, that's the law of the Supreme Court. And you're right, I clerked for both men. I admire both men greatly. Both taught me an awful lot. And I'm not here, and I will not say a bad word about either one of those gentlemen.
Well, I wrestle with your admiration for Justice White when his jurisprudence fails to recognize what I and the current Supreme Court and many Americans view as a core liberty interest inherent on each one of us. Obviously, justices can be revered for their writing and their decisions, even when developments in the law and history have long passed them by. You've also expressed admiration for Justice Scalia, and he dissented sharply, memorably, in both of these same-sex decisions. He actually said in one of those dissents memorably that the majority's holding would mean, and I quote, that state laws against bigamy, same-sex marriage, adult incest, prostitution, adultery, fornication, bestiality, and obscenity would be called into question. As a legal matter, do you agree with Justice Scalia's statement in that dissent?
Senator, that's a dissent. It's not the controlling law
That's right.
of the Supreme Court.
And sometimes
And
dissents
Senator-
are meant to signal a direction a certain justice would like the law to go.
I'm sure it does, but it's a dissent. And Senator, with respect to Justice White, I'm not here to spend undue amount of time defending him. But we all, everyone, I know you've indicated you disagree with him. That's fine. Every one of us makes mistakes at some point in time.
Did he
And
make
I
a
don't
mistake
think-
in Bowers?
Senator, the Supreme Court has held that. Justice Kennedy held that. As you pointed out, you read the language. That's the binding law of the Supreme Court of the United States. And Senator, I revere both men greatly.
But if you would, Judge, what I'm looking for is some sense of your understanding of the scope of this substantive due process analysis in Casey, because you took the initiative to write that it should be understood very narrowly, that it might not be something that would stand the test of time, because a justice you identified as your judicial hero didn't agree with it, and a justice you did not describe as your judicial hero overturned it. So I'm
Senator,
just
I'm sorry to
expressing
interrupt
concern.
you, but that's not correct.
Okay.
If you took away from my discussion that I don't consider Justice Kennedy a judicial hero, then I'm sorry, because I thought I made that very clear in my opening remarks before this body. And if I didn't, I want to make it real clear right now, all right, that I am
Duly noted,
immensely grateful. Senator, I can't let that pass. I'm sorry.
You did note in
Justice-
your opening
Justice-
that you learned
Justice-
from him respect for
No.
litigants and that you admired your time with him. And I remember you saying very positive things about your clerkship
I'm
with
glad.
Justice.
I'm glad that I do not want the record of this committee to go down in history as anything less than holding him in great admiration. That's very important to me, Senator.
Thank you.
Very important to me.
Justice Scalia, for whom you've also expressed a great deal of admiration, expressed in his other dissent, key one in this case, that Obergefell literally was undermining American democracy, that it was a threat to American democracy. Presumably, he was referring to the fact the court's decision struck down state laws adopted by referenda. What did you understand him to mean? Do you view Obergefell as a threat to democracy somehow?
Senator, Justice Scalia had his views, and he expressed them in his dissent. They're his views. The law of the land is the holding of the Supreme Court in Obergefell.
That's right. Your views you expressed in 2005 in an article in National Review called Liberals and Lawsuits. And in that article, you said marriage equality and death with dignity cases were examples of what liberals relied on an overweening addiction to the courtroom to advance. What did you mean by that?
Senator, we discussed that article yesterday. I'm happy to do it again. And I was pointing out there, I think, two things, and I'd add a third. The first I was pointing out was that there are important civil rights issues that courts have to be available for, and that courts are open to all persons. And one of the beauties of our courts is that they can vindicate civil rights for minorities.
That's right.
It's a non-majoritarian institution.
And the line of cases I've been working through with you are two that are landmark cases but that also have memorable dissents, where significant advances in civil rights were made. And that's exactly what I was trying to explore, why you sort of picked out those two areas to, I'll say, denigrate in this National Review article. Maybe I misread it.
I don't mean to denigrate anyone's views, Senator. This was before I was a judge. And second point I made was that there are some comparative disadvantages to resolving policy matters for courts. One of the disadvantages comparatively is that judges are not well equipped to decide policy matters. We have 4 evanescent law clerks that come to us for a year out of law school. Great policymakers, they are not, with all respect to my law clerks. All right? They're wonderful legal researchers, but they're not great policymakers.
Speaking as a former clerk, I appreciate the recognition that some are great legal researchers. I'm not sure I was either a good policy advisor or researcher for my judge.
Right. So
Let me, if I can, move to asking you about the basis on which you might ever be open to reconsidering, as Kennedy did of White's decision in Bowers with Lawrence, the decision in Obergefell. Obergefell, which recognized a constitutional right to marriage, equality for same-sex couples rooted in this substantive due process, is something that is now settled law, and on which I'd say there's now a great deal of reliance. One of your core factors, one of the core factors in deciding whether or not a precedential decision should be reviewed. Do you think there's significant reliance interests on Obergefell?
I'm sure there are, Senator, yes.
And would you include in that the thousands, probably tens of thousands of couples that have now married and purchased property and signed contracts and changes in state law and municipal law such that you would agree there's really a significant reliance interest on this decision?
Reliance interests are, as you point out, Senator, an important factor in any consideration of precedent. Absolutely.
And so overturning this key piece of precedent would not just disrespect the now 25-year-long settled mystery of life analysis of Casey and the settled Lawrence decision, but also the reliance interests of many couples in this Obergefell decision.
Senator, I have declined to make any promises, hints, or previews in how I'd resolve any case.
That's right.
And I'm going to continue that here.
But I'm simply asking if you think there's a significant reliance interest.
And I've already said yes.
Let me just turn, if I might, in the little time I've got left, and we might pick this up in my last round, to an important decision on the same question of 14th Amendment substantive due process right in Browder versus City of Albuquerque. We talked yesterday about you being a Westerner, and this is a particularly Western case in which a police officer going off shift decided to just roar through the middle of town at 66 miles an hour, speeding through 11 different intersections and tragically one red light, killing a person and severely injuring another. The federal access to the federal courts in this case rests on 42, Section 1983. And your own decision, the unanimous decision of the 10th Circuit that you wrote, describes substantive due process, which is the foundation of all these privacy cases we were just talking about, as very much uncharted, more than a little open-ended, a murky area with a paradoxical name. What did you mean by all that in this case?
Senator, a lot of that was quotes from other cases, as I recall.
2 out of the 4, yes.
Oh, all right. From the Supreme Court.
I was a law clerk.
Yeah, and just so we're dead accurate here, I think those are quotes from the United States Supreme Court.
Yes, they are.
All right. I think that's not an insignificant fact to note, Senator.
It's not insignificant.
Okay. And in that case, the question was whether there's a substantive due process right to pursue not a privacy interest, but a lawsuit against, a tort-type lawsuit against a police officer for this conduct. And we have precedent in the 10th Circuit saying, indeed, there is. And in that case, in the majority opinion that I wrote for the court, I upheld the right of the family to pursue the police officer for damages under the United States Constitution.
That's right. And if I might, Mr. Chairman, I have a follow-on question, which we'll get to in the third round.
Okay?
Thank you.
Senator Flake.